Welcome back to Take Action News, everybody. David Shuster here, along with the team of Daniel Marins, Rich Webster, and joining us is Shane Farnan. He is a talk radio news service Supreme Court reporter, longtime friend of We Act Radio, Take Action News, also an esteemed graduate of the University of Michigan. Shane, welcome to the program.
David Shuster, how are you?
I'm great. I forgot to mention that in that recitation there, you're also a lawyer. You've got your law degree, and you were at the Supreme Court this past week. You actually heard the hearings over the Voting Rights Act challenge. First, explain what the challenge was all about, why it's so significant, and what you saw.
Sure. It actually goes back quite a long ways, back to the Civil War, believe it or not. And, of course, after the Civil War, there were two amendments to the Constitution that were enacted, the 14th and 15th. Everyone knows the 14th as equal rights for everybody. Doesn't matter if you used to be a slave, a person of color, or anything like that. Then there was the 15th Amendment, which said everybody has the right to vote, no matter what color. And the second sentence of the 15th Amendment says Congress has the power to enact laws to make sure this happens. And for about 100 years after the Civil War, blacks in the South especially were not given the right to vote. All kinds of laws were enacted at the local level. For example, literacy tests in order to register, which prevented, which took away the right to vote from many people of color. So back, in 1964 we had the Civil Rights Act. 1965, we had the Voting Rights Act. And what this did was said, there's a number of sections to it, but the one at issue before the Supreme Court today, which is being challenged, is Section 5. Now, what Section 5 of the Voting Rights Act says, that in these specific states which have a history of discriminating against people of color in the voting box or registration or to, lines, anything like that, if you want to change your voting laws locally, you can't do so unless the Department of Justice or a three-judge panel in D.C. says you can. It's called the pre-clearance section of the Voting Rights Act. And ever since 1965, the Voting Rights Act in 1965 was only for 4 years. And Congress, from time to time, has reauthorized this, most recently in 2006. And each time they do, usually actually always, Republicans challenge it in the court. Mm-hmm. This was the most recent challenge. Shelby, Alabama, a county in Alabama, brought an action saying, we don't want to be subjected to this preclearance anymore. It's unconstitutional. Congress has gone beyond its authority because the problem's been solved. There's no, the South has changed, is one of the statements that was actually said in the court this past Wednesday. So that's what the judges heard,